that?
These days, I'm gullible Susan.
Oh my goodness.
Well, I don't know. I mean, it could be something like this.
Electric bike, little air conditioning unit built in, little helmet on the electric bike to keep it cool.
I bet if I looked hard enough on the internet, I would find.
You would probably.
Oh, here she comes.
Terry, you handling the meeting now?
No, Eleanor is actually on her way out.
Ed, that was a nice tribute to your father-in-law. It was really nice.
Yes.
It was really a beautiful day.
Today you are going to be.
Karen.
Are you almost there?
We could run there.
I thought I saw Lisa's car driving the other direction as fast as possible.
She was running away. Thanks for coming, Mark.
Thanks for the donuts, by the way.
Oh. How are they?
Yes.
Yes.
Oh, they signed us with Sharpie. Yeah, so I can just go around and sign plans. No. No. It just shows up best.
So does September meeting look like it's going to be non-eventful in terms of participation?
Oh, I don't know.
I'm not going to be here.
Where are you going? Somewhere fun? Not
I
telling?
bought an Airstream trailer. We're going traveling.
For how long?
We don't know yet.
That's amazing.
We paid off our mortgage, so
Good for
we're
you. Out. Awesome. That sounds really cool.
we'll see. It could be deadly.
Well, maybe one of you will come back.
Yes.
The other one will
Yes.
decide to stay wherever you end up.
Yes.
I
put
brought
out
my
a
husband and I could not do that.
$4 million umbrella policy. So we'll see where it
You
goes.
might go to the Grand Canyon and do a little push.
Right over the cliff.
What happened?
I've
Oh, I
been
don't
there
know.
before.
Oh, so you don't have to go there again.
Oh no,
No.
I'd love to go back.
Um,
I spent 7 days rafting down the Colorado. It was awesome.
that sounds awesome.
It was awesome. It was, it's like a bucket list item.
Yeah.
It was so good.
So did you guys make a bucket list for this trip?
Not yet.
Sounds so
I
exciting.
think we're gonna go up to Michigan, and we're gonna go to Mackinac Island, and we're gonna travel west, and
Cool.
hopefully not get any hurricane shock.
Already? We haven't even started yet already.
Yeah,
How are
eat
you,
the
Lisa?
chocolate
Your
and
hair
get
looks
it
awesome.
done.
Oh,
All right.
Love it. Did you cut it shorter? No, it looks great.
Thank you.
Okay.
this weather, it's like Mufasa. I'm like, oh God. It's pretty small.
Okay. Starting to revive.
As far as I know, yes. I don't control the video.
Somebody else asked me if you could watch this live streaming.
This
You
one
should be able
can. This one will live stream.
Yeah, your wife watches it sometimes, right?
After the last meeting, I had like 3 or 4 people come up to me and tell me they watched it.
On the bit, yeah, no.
On the 40B?
I
Yeah.
can't,
Yeah.
can't remember who asked me. I think it was related to the 40B.
I think we just switched over to the new system. So this room will live stream, but upstairs does not live stream.
Right. All right. Anyway, this is the regularly scheduled Town of Nantucket Board of Appeals meeting for August 8th, 2018. Can I get on a?
The 8th.
The 9th.
9th.
It's a 9th.
It's the 9th?
Today, yeah.
It is the 9th. August 9th, 2018. So, can I get a motion to approve the agenda as written? Okay. Any further discussion?
Nope.
No. All those in favor say aye.
Aye.
Okay, how about approval of the minutes of July 12th, 2018? There was a slight error with the date on the ones we received in the packet. I think it said the 14th.
It said the 11th on the top, but
11th,
the actual
right.
body of the thing said the 12th, but your header on the top is needed.
Said
to be
11?
delivered.
Yeah. So anyway, it's with that slight amendment. I read them, they look fine to me.
Right. This was
Oh,
the
right.
12th, so this was okay then.
Yeah. Yeah.
Okay. Yeah, I read them. They looked fine.
I'll make a motion.
Okay. Whoever makes the motion, who wants to second that?
I'll second it.
Lisa seconds it. Any further discussion? No. All those in favor say aye. Aye.
Aye.
Okay, so moving on. 5103 Rugged Scott LLC, Rugged Scott aka Beach Plum 40B for the applicant.
So I'm out on this one,
Okay.
right?
I don't think you have to be, but
I
that's fine.
I don't have to be.
I don't think you have to be.
Okay.
Because you didn't sit before?
I didn't sit, well, because I originally had recused because but it was on a different thing. It wasn't on a modification. It was on one of the owners. Why did I recused because I was working with Cohen and Cohen, and then I recused again because it turns out that Cohen, even though I didn't work on it, Cohen had represented one of the buyers in the lawsuit.
Totally different lot.
Yeah, it was
I
totally.
don't think.
Okay, all right, cool. I don't care. Fine.
Are you okay with it?
Sure. Yeah.
Okay.
For the applicant, Marianne Hanley, what we're asking today is a minor modification of the comprehensive permit to allow for the redivision of 12 Woodley Road, which is currently shown as Lot 16 on the subdivision plan, into a larger lot where the house will be on it and a smaller lot where the garage that was the subject, or is the subject of the garage easement, would be located. The smaller lot with the garage on it would then be conveyed to the owners of Lot 17 to be merged with their existing property for building and zoning purposes. So basically, the reason we're doing this is just to eliminate the use of the easement and actually allow the person that's going to be using the garage to own the land underneath it. And as part of that, I also need you to sign a subdivision plan so that we can record it at the Registry of Deeds.
Okay.
So it's a completely separate lot that they'll parcel 17A.
17A would be the separate lot to be conveyed. The house would still be on Lot 16, and Lot 17 and 17A would have a house with a garage.
And I can't read. How big is the lot?
Here, I'm going to show you.
Not that it matters.
But 17A and 17 will become one.
They're
For
gonna
building
be,
and zoning purposes, they would be deemed merged. Yeah.
It's 5. I think it says 5
And why isn't the planning board dealing with this?
Because you're the
It's a
permit
40B.
because it's a
granting
40B.
authority.
All right.
Okay, this is.
Oh, 830.
830 square feet. The easement area was actually 831 square feet. So we just drew a line around it. And then if we do this, that would, instead of dealing with the easement in the survey in the state, and for the next 50 or 100 years, it merely allows this lot to be owned by this owner, and this lot is going to be used in the garage.
I'm just curious, why would you just change the perimeter of this lot?
Exactly.
Because they don't own this. This lot is owned separately by someone else. So in order to take this lot out of this ownership, we have to carve it off.
I didn't catch your question. What did you?
Whether or not why it had to be carved out as a separate lot and why you couldn't just
Exactly.
change the line. That I don't.
Because we've got two different owners. So there has to be a deed, there has to be a conveyance of this piece of property.
Got it. I understand. You have to create that lot
Right.
to convey to
Yeah.
them, then this will become a
Yeah.
new a
With
one
the
lot.
easement, we just do an easement agreement, but there actually
Right.
has to be a transfer of ownership
Of
that
that
small lot.
830 square feet. Right.
And you can't do that without
Without
filing a
creating a
plan
lot.
at the registry of deeds.
What
And-
about? Go ahead.
No, go ahead.
What about stuff like regularity factor? Does that?
We
come
should
into
be all
play?
set on that. I had the surveyors check it. There's actually a waiver from any regularity requirements anyway in the original comprehensive permit. But I made sure that they checked all of this, so at the end of the day, when this is combined with this, it's not a problem, and when this is by itself, it's fine too.
So each lot will be conforming at the end of the day?
Well, not
No.
No, because nothing's
conforming.
conforming there.
Okay.
Yeah, yeah.
All right.
And is the
But
three?
basically, this lot 16 on this plan, not to be confused with old 16, would have, what does it say,
8,591.
591 square feet, and 17 and 17A combined would be 325 square feet.
And this 3 feet is the setback around the entire proposed garage,
Right.
and it has this garage. This has been approved by the
This was
HDC.
this was on the original plan, this
Yeah.
garage, and it was actually only a foot from the roadway. This is 3 feet, and this is how it was approved on the easement as well.
Right, and this has gone to the HDC.
Yes, we actually have building permits have been filed, and they will be issued hopefully the beginning of September.
Does anybody want to see the bigger plan down there?
Well, you have to sign it, so you'll see it anyway.
Well, I thought they might want to see before they had to sign it.
All right.
So we have, first, don't we have to do insubstantial or substantial?
I believe so. Yeah.
Yeah.
That would be, anybody else? Do you have any questions down there? Or? I mean, the ground cover, basically nothing changes in that regard. The extra ground cover goes to lot 17.
Yeah, I mean, the percentages change because a lot areas are changing, but it's the same structures.
So to clarify, it will remain a separate lot then?
Yeah, it would be, on the deed, it will say they'd be deemed merged for building and zoning purposes, which it's not unusual. We do this all the time, we merge properties.
Do we need to do anything to limit, to make sure
Good-
the
make
use
sure
of that lot 17 is limited to the use of the garage?
Well, because if they're merged for zoning purposes, what you're saying is you would never be able to take that garage down and build another dwelling because they'd be merged.
Right, you can't have two dwellings in the subdivision anyway.
But what Jeff is saying is if it's
But
a
if
separate
it's
lot,
But it'll merge.
But it's merged for building and zoning
Right.
purposes because it's only 800 square
Right,
feet. You couldn't build a
couldn't-
house on it.
Right.
And
You can't build a-
under
yeah.
zoning, they're automatically gonna be deemed merged, and we will also have in the deed to the owner of lot 17, and understanding that by their accepting this deed, they agree and they understand, and it's just one big lot. And we're also gonna have your decision.
yeah, I think,
as
I
a
mean,
minor
that should definitely
modification,
be
which is gonna
a
specify it
finding
as well. And
Right.
that they will not,
that's gonna
that,
get recorded
Why?
right
Why?
on the deed.
Just I don't understand it. Also, why, when this is conveyed to 17, doesn't it become one lot?
yeah,
Building
why,
and zoning purposes, it does.
but why
It's
don't they,
merged.
couldn't they just do a new plan
They
that just
could
did a
do
new perimeter
if they
plan?
wanted
Yes,
to, but they
I
don't
think we
have
need,
to.
well,
Well,
I
it
think
might
we
make
should see it.
people on the board feel better.
Yeah.
If a new plan was created that, would that piece as 17, is that what you're,
Yeah, I mean, the bottom line here, I
But
think,
that would be basically just a perimeter plan, which wouldn't
That's
require
okay.
any action by the board.
And it doesn't get recorded or anything.
Well, it could get recorded, but it still doesn't require any action by the board. The subdivision, changing the lot lines is what requires your signature.
yeah, I think the only concern is just to have something that's recorded that says that this lot is no longer separate. I mean, I understand what you're saying, I'm trying to,
That will be in the decision.
It will be in the findings, so maybe, as long
And
as
it
it's
will
in our
say in the-
finding.
Well, is there any real quote-unquote decision if we deem this insubstantial?
I issue a memo that goes in the building permit file, it's filed with the town clerk as well. So there is something of record, because there was a period of time before I started here where there were some minor modifications that the board approved, and there wasn't really a good record of it, so I'm trying to rectify that by having things filed with the town clerk and placed in the building permit.
I mean, this isn't registered land, right? So we could, right, it's not registered, is it?
No.
So we could record the memo if that made,
Well,
I
I
mean,
probably will record it.
Yeah.
It's filed with the town clerk, and I very definitely would record it because I want to make sure that it's not a problem for what I have remaining. So I definitely will
Right.
record
The
it. And
other
if
lot.
the owner wants to track the language in here that specific, at the end says, upon such transfer, they're deemed merged as one lot for building and zoning
And you could
purposes.
marginally reference it against the deed to the owners of lot
Right.
17 as well.
Yeah,
Just to be clear, though, I believe that all we're discussing initially is whether it's substantial or insubstantial. If it's insubstantial, we don't get to put conditions.
Well,
or
we could put why we found it insubstantial.
just more of a finding, if you will.
yeah, finding.
right, and then that's what her memo is, and you file the memo with the town clerk?
Yep.
So then,
And you would reference the deed.
It's a memo with a letter attached to Ed signs.
Oh, not the statement that you said that the deed will say that they would be,
In the memo, she can reference the deed.
yes, that's what I'm
Sorry,
saying.
misunderstood.
so, I mean, you know, you wouldn't, once they merge, they're merged. I mean,
Once they merge, they're merged.
And I guess the only question about it being insubstantial versus substantial is nobody has been notified that this garage is going in, or they have from, it was always been on the plan, so that's not a change.
It's always
I'm just trying to see if there's any reason that you would feel like the neighbors had to be notified.
Do we have a layout of this garage, just literally for pulling a vehicle in, or is there a mystery second story with all kinds of other stuff going on?
No, there's no mystery second story. They would access the garage the way that the agency
underground
approved it from the front, from here.
Is it one story, do you remember? I don't remember
I
the
have no
HGC
idea.
plan.
I mean, we already,
Actually, the garage exists. It's one story. It's the garage on lot 10.
Right.
Lot 20 that's getting moved over.
I think it's literally being moved.
It's being picked up. And,
oh,
well, it's not quite as simple as just picking up and moving it, but that, in the end of the day, is what we would be accomplishing.
I think as an exhibit, we should have approved plans from the HDC as part of any decision that is positive
Yeah.
here.
All right, well, again, then I think what we would be saying is it's substantial and come back. I thought that was, if it's insubstantial, we just deem it insubstantial and it's basically granted as the applicant asked for it.
Correct.
So,
But the letter that you signed, you may have remembered having signed a few of these this year, will iterate basically the content of our discussion, without going into tremendous detail, but just to explain as.
right, but I'm simply saying I don't think we can put, that, we want the HDC plans attached to it.
Yeah, I think we need an exhibit
You know,
as
I
part
don't
of this
think- From a
decision.
technical standpoint, I'm not saying I
Why?
have a
Yeah.
fundamental.
How come,
Why?
you didn't require them when you did the, as an insubstantial modification garage easement? I mean, really what we're asking for here is to merge these two lots. Whether the garage ever gets built or not, the lots will be merged.
Well, quite frankly, since we've done so much with this, I don't remember, was that a substantial or
It was
insubstantial?
insubstantial, I've copied it here.
I put in the staff report at the end of all that previous documentation regarding this garage approval.
I mean, if the garage already exists, it already went through HGC approval and it's
It
getting,
doesn't exist.
Well, it doesn't exist there, it
doesn't
exists
exist in
across
this
the street.
location.
but it's on,
It-
Right,
It's
but-
on
but it-
paper, it's not on the ground.
It's across the street.
Right, and we
no, but
basically
it physically exists across the street,
Yeah,
correct?
exactly.
And physically is moving off of that lot, and so it was approved by the HGC.
And it has been approved on this location by the HDC because we have a building permit. I mean,
So,
the building permits will be issued, they can't be issued until the electrical service to the existing garage
It's
gets
cut off.
disconnected. And that's scheduled to happen hopefully right after Labor Day, because we're trying to get this done before the owners of lot 17 go back home for the winter, and the owners of lot 20 are very anxious to get this done.
All right, what is, given all we're really talking about is insubstantial, substantial. Insubstantial means, like I said, we basically deem it insubstantial and it's approved as requested. If we want to have any further discussion about it, or conditions, or HDC, or anything else, it has to be substantial, in which case we would talk about it next month. I mean, I don't have any problem with the thought of it.
I don't think we have to make it substantial. I just feel like we already talked about the fact that we, you know, if we wanted to, that it was insubstantial to put the garage use.
One previous mess, I
I don't wanna make any more of a mess than it probably already is, but I'm saying I'd like to back everything up. I don't see the issue with putting in an exhibit in to back up what we're actually saying can go back in there.
The exhibit will be attached to your memo, won't it?
Yeah, it doesn't have to, that won't in and of itself make it substantial, right? If we can say it's insubstantial and then just put all of our documentation on the letter,
That's
on the
what I'm
memo.
saying.
Yeah.
And then the memo is recorded.
Well,
Yes,
the memo
I have
can be
this.
recorded, and I'm good with all that, but we can't impose a condition, for instance, where we demand seeing the HDC plans, is all I'm saying. I mean, we could go
But
so
why
far.
do we need the HD? Why do we need to see the plans?
I agree.
Well, Karen asked about it.
changed at all, correct? It's not, the garage isn't being modified.
It's just a move. It's just a move. It's just a move on, move
So
off
if they come
plan.
back, but if we okay this and they come
Nope.
back in another year and they
No
wanna put
plumbing,
another story
no
on their garage,
other issues. in
Well,
the
then-
garage.
and then we already have complications that we're probably gonna have with 40Bs from this point on. I think we've already come to that conclusion, so why not back everything up? Just saying.
Well, I'm all
I'm
we're
easy
approving is
either
this,
way. Well, this
this
relative.
lot, to put this, to put
Right,
the garage
like,
on
I
it.
feel like
If they
we-
wanna change the configuration of the garage in the future, yes, they have to come back.
Yeah, like I just feel like we've already,
Part of the complex.
the garage itself was already
Already
approved and it physically exists on another lot, so we've already gone through.
Yeah, but
So,
we,
but what you're saying is that on that other lot, there may be restrictions like no plumbing, no this, no that, that now won't be on this lot?
yeah, I
But
think
wouldn't
that's-
but weren't those approved, all those garages approved as part of the comp permit? So any garage that gets built in this subdivision, like there's already restrictions on like no renting or no, no whatever, like it should already exist, I feel like.
One would hope, but I doubt, I don't know that for a fact.
And I-
wouldn't
Put
be
it simply,
surprised.
all we're doing is just ignore lot 17, we're, existing lot 16, excuse me, comes up here and goes, all we're doing is we're carving off this little piece and saying, here, this is for you, and you're gonna put your
Right.
garage on it. The garage was approved in this location back in 2006.
Right, we already approved the garage here. We're only talking about creating it as a separate lot so it can be conveyed. The garage has been approved in that location.
Right,
As insubstantial.
right.
Yeah,
So I don't really know how to make,
Right, I think we've
why would it
already,
become substantial now?
I feel like we already covered all of this.
Horses out of the
All right,
barn.
so.
I say it's
let's vote on it then.
insubstantial,
Okay.
Okay, I would
or I
agree.
make the motion that that this is insubstantial.
I would agree with that.
Okay.
But with the
Unsubstantial,
understanding.
what is the word? Unsubstantial?
Insubstantial, with the understanding that the memo will outline the things we discussed.
Is the memo gonna get signed?
I think Ed signs it.
Ed signs it, I think, yeah, Eleanor
And then
drafts
it
it.
gets filed with the town clerk, and we can record it.
That's fine.
All right.
Okay, we're
Did
good
you make
with
that motion?
It made that motion.
I'll second it.
All right, Susan made a motion. Was there anybody in the audience who wanted to speak about this? No.
Where do we sign this?
So, and Lisa seconded. Any further discussion? No. So, all those in favor say aye.
Aye. And we just
Do
signed
we
it.
need a
So-
special pen for that? Yeah.
Apparently, Sharpie works.
Oops, sorry, it's open.
Who knew?
Who knew?
Who's voting?
What would be the 5 regular members?
The main board.
Would anyone vote against it?
No.
Okay, so it's unanimous.
Yeah.
Will you send it back before the?
Okay.
That might be the first plan I've ever signed.
It's gotta be scanned.
It's gonna always, I'll scan that. Scan that to be individual. I sent you a paper plan. The good one?
She'll need that one,
Oh, okay.
the scan.
I can do that.
Okay.
Thank you very much.
Thank you.
Thank you.
All right, 1918 Act Crazy LLC, 9 Westchester Street, for the applicant. Just re-identify yourself and tell us what's going
Hi,
on.
my name is Juraj Benkat, and actually last time we talked about all the changes we proposed for the back additional back part of the building. You wanted to see some more plans, pretty much as built, and see how we're actually trying to rebuild the foundation, which is most important part there, without interrupt or getting into the neighbor's property. So I have the plans here. I have some proposed way how we want to do the foundation, and some notes from the engineer who checked and wrote a note about all the steps what we're going to do.
Okay.
So if I remember correctly, it's all about construction protocol, right?
Pretty much.
Yeah.
And we were just curious. I mean, I was just.
You read this one, right?
Yeah.
Yeah.
Can you?
I have 5 copies.
Can I ask you a question?
Well, we can share.
Yep.
So I can't read this print. What is the height of this peak at the moment, as comparison to what you're?
Full set. I think it's like 17 feet or so.
Oh, so that's going now to 21 something?
Yeah. So it's a little bit thin.
Do you want to look at this, Lisa, the big one?
Oh, okay.
And then I can share it.
Yeah.
That's simple. You look at that.
Okay.
Do you have more copies of these?
He has 5.
All right. Hand them
I'm like, that's right. I'm like, he has 5.
They are pink. Okay.
You're sitting on it as well, aren't you?
So this is the existing.
Well, but if you're at the table, it means you're sitting there.
Yeah. Do you need a set of plans over there? 'Cause
17
we've got
So
one
it's
here.
basically 18 feet. And it's going to,
Those are existing.
Or then, if you don't need them, then.
Proposed already submitted last time, so it's just existing right now.
Big copies.
Yeah.
Do we have the proposed?
we don't have the large proposed.
But we have small.
Weren't we looking for existing?
Yeah, that's existing. This is existing.
Okay.
Yeah, that's what we wanted
Okay.
to
So
see, and
So the section that's the closest to the property line is currently 18 feet tall, and it's going to, how high, did you say?
it was around 22 feet. 21, 6,
Really?
22.
That looks tall.
This is proposed. This is gonna be 22 feet, and it's, that was from the old packet. So here, I'll show you. You can turn this over now. That's this. So right now
Oh,
it's
okay.
18,
All right.
and that's this section that's right on the property line. And it's going to 22.
Could you repeat that?
Oh, I'm sorry. Looked at from the south, the far, let's see, so that would be north-southwesterly elevation is
This
going,
existing house.
yeah,
Okay.
it would, it is going from 18 feet to 22 feet. in height.
Well, that's to the ridge. Is that primarily because the ridge direction is changing
ridge.
and it gets wider and then gets up to the
Yeah,
peak?
exactly. Yeah, the ridge direction is changing.
So the
So-
floor levels don't change, it's just
Uh,
because of the width.
Well, he's
Yeah,
combining
more or
the
less,
roofs,
because there is
too.
actually a loft, so
You know,
we
right
are
now
going
it's-
with the full story
Yeah, it
now, not
looks
the
like
loft,
that.
but then the roof goes all
And
the
now
way,
they're making
the
one
whole
bigger
length, not
roof,
only
and from
the
the
little part
side
you
it
see.
looks like that,
Which-
as opposed to.
I mean, that was approved by the HDC
So
also.
all I'm saying is if you make this a gable, it's going to get up to the 21. It's really this height that would be, if you were worried about it, that's the one.
No, I just want to be clear that everybody realizes that's getting taller in the setback. Oh,
Yeah.
sorry. Because as you look here, the eave is much lower at the property line here. So if the peak in the existing is at 18, the eave is probably at, 16 or 15, and here the full face will be 22 feet.
Yeah, no, I hear you.
It's just,
Um,
and it's.
Also, it was already approved by the HDC, all these elevations.
No, I know that. I'm not talking aesthetics. I'm talking just that it's 8 inches.
height.
It's less than a foot away from that property line, and it's going up substantially higher.
Arthur,
Right.
does your client have a concern about that height?
No, not about the height, no.
Okay.
And you're totally regarding the fireproofing that you need to do this? Windows, if they're in that elevation, need to be fireproofed with shutters, because you're that close to the property line. You need to put sheathing on the building that is fireproof, because you're that close to the
Yep.
property line.
Yep.
All
I
that's
mean,
good.
those are building code issues that
Yeah,
they would have
yeah,
to
we
comply
can-
They're all
with.
building code issues,
Yeah, all-
but I'm just saying.
it's all good, we can do
let's,
that.
You know, let's be
No, I
clear.
hear you, but,
We can do all these. That's no problem. We can do fire rated walls, and the main issue was we didn't want to disturb the ground at the neighbor's property. That's why we were trying to figure out how we actually reinforce the existing foundation, and then if anything that goes above is the easy part, I would say. You just need to figure out the way with the neighbor when we can work on the
Sure.
upper
our
structure
conditions
and don't get
on
into
the project.
their
method.
property
This
too
shows
much.
the foundation
The
details
methods.
It's
And does
all
he have a
being
letter?
done from inside, and there was a letter from the engineer.
And it's only the red part that's being created in the foundation?
Yeah, the foundation is being rebuilt, but it will be new. But the red part is what is going to be actually reinforced or
But this whole part is shown as clear,
Fixed.
as it's remaining.
front. Yeah, the front part is we're not changing that.
Yeah,
No, only
this
the
is the
back.
part that has
Yeah,
That's expansion.
Yeah.
Well, it's not expansion, the
It's
wall
the
is out
existing-
here now.
it's the
This
existing
is showing
footprint.
that's where they're gonna use the interior,
This,
reinforcement.
Okay.
From the engineer Michelle Cudillo,
Cadulo, yeah.
Yeah.
due to the close proximity of abutting landscaping pavers and retaining walls, a portion of this area foundation will remain and encased in a new inside-facing foundation wall and footing to protect the boundary of the building and support the loads above.
and it's just a crawl space.
I have no.
So it sounds like they're gonna undermine the existing crawl space and build new foundation haunch inside. Is that,
No,
no?
they're just,
It's an existing
no.
full height wall, and just
I-
Yeah.
Is it?
No.
Okay.
Yeah, we're going
Alright.
same depth as the existing.
4-foot
yeah.
wall
It goes
on the
4 feet.
areas. It's only that where it gets close to the west.
All right, Arthur, did you have specific concerns?
Yeah, specifically, as you know, I represent the abutters on each side, Allen and Taylor Breed. They own the houses and lots on each side of this locus. And as you know, the work that's going to be done is very close, within inches of the lot line. We'd had discussion before about the possibility that they would need to come over on our side of the property line in connection with the work. We've indicated that that's not something that we're
unalterably opposed to. We'd be happy to cooperate as far as that's concerned with appropriate safeguards. Now, what you have here is a plan by which we just received a couple of days ago, by which they propose to do the work entirely from the inside without having to come over on our side. I have some question.
Only the foundation work they can do from the inside.
They'll have to shingle.
Right.
What they do on the outside, they're gonna have to.
That's right. They're certainly going to have to
Ladders,
come over.
Staging, things like that.
And as far as the foundation is concerned, we just got the report, and we haven't had a chance to have it reviewed by an engineer, and we'd like to do that. We want to make sure, and I think it's in everyone's best interest, that we confirm that the method that they intend to use with regard to the foundation would be successful and would not have any adverse impact upon our property. And therefore, what I would like to request, again, we're not opposed to any of the work that they're doing per se. We're just concerned with it's being done the right way, and that any effect that it has upon our property be either protected or dealt with subsequently. But we would like to request that there be a continuance on this matter until the next meeting to give us an opportunity to have an engineer of our choice take a look at the situation, look at the brief report from Mr. Cadillo, and give us any recommendations that he or she may have.
How do you feel about entering into some sort of agreement prior to that next meeting that spells out your client's willingness or unwillingness to give access to these property owners to do work like shingling and painting and things like that?
I mean, there's been some discussion about that, although nothing specific, and we'd like to see some more specific indication as to what they would like to do. I mean, a more formal request as to what we were doing. I would comment that I'm going to be away the rest of this month after this week. So it may not be an awful lot that we can pull together as far as that agreement is concerned, but when I get back the beginning of September, we should be able to, before the meeting, give it at least some attention to get it resolved at that point. But in any event, what I'd like to do would be to get an engineer to take a look, as I say, at what we've got, the plan that we've got and the report from Mr. Cadillo, and make any recommendations that would protect us, and as far as that's concerned, I think be beneficial to the project to have available.
Arthur, if I may, Mr. Chairman, there are a number of us that are not here in September.
Yeah, we're not, the September meeting is proving to be difficult, so we can discuss that issue right now.
I just wanted to bring it to the table.
Yep. The September meeting is scheduled for the 13th. I won't be here, Lisa won't be here, and Mark won't be here. So we either have to pick another date or continue knowing that this won't be heard on the 13th. Either one is acceptable to me.
And you're leaving next week? No, end of the month.
No, I'll be gone around the 13th.
Okay, so we could do it before that.
I mean, we could do it the previous Thursday on the 6th.
Do the whole meeting, or just this particular?
I would say you do the whole meeting. How does everyone feel about that?
Yeah.
Is Mr. Reed gonna have enough time to?
Well, I'm obviously, between today and tomorrow, I'm going to work on getting an engineer to take a look at it.
Well, let's assume
and I'll be back on the 31st.
Let's assume for the sake of argument that the engineering is okay. I think Jeff's question is, because we did request this in the last meeting, it was part of the...
Sorry, but I mean, it was signed by and done by engineer, so...
No, but we went further to say, and we have an agreement in place that proves, well, it says here that proves there's no need to go on the neighbor's property. I don't think that's the truth. You cannot do this job without going on the neighbor's property.
For the foundation.
Yeah,
right, but the rest of it.
The rest of it will have to be done, of course, yeah, that's what we talked about.
Well, that's
we
what
didn't want to disturb the ground and whatever is built there, but let's say, the gable wall can be framed and stood up. Yeah, they need to have agreement, yeah. They need to have agreement, but I would say, if we maybe agree on what our engineer proposed and is signed by her, and by the time we start or get building permit, we can figure out all other steps.
No.
How do we?
That's
how
not
do we
gonna
do it?
happen. I mean, I don't, this has been going on for months on end.
Yeah.
You would think that, quite frankly, you would have approached the neighbor by now and had an agreement. You have to go
That's
on
what I
their
was-
property.
Yeah, I mean, that's what they're trying to find an agreement with the owner, but looks like
Is there any
they talked, but
contentious
I
issue
didn't see any,
at this
any,
point?
I don't know how to make it.
No contentious issue, just having an agreement in place, having a specific idea and protocol as to what they plan to do, and having appropriate protection, including indemnification and liability provisions and the other things that you'd normally expect in an agreement in that place. As I say, there have been discussions, brief discussions between my clients and the property owner, who hasn't been represented by counsel up to the present time, but nothing has really flowed from that other than just general discussion. As I've said, under any reasonable circumstances, my clients are willing to cooperate in a reasonable way as long as their interests are not being harmed as a result.
All right, do we feel fairly strongly about the letter needs to be in place?
Absolutely. I mean, personally, I believe that.
I mean, I don't think, given it's a crawl space, that it's that big a deal to reinforce the existing foundation from the inside of the building.
No, I agree 100%.
So what we're talking about, I think, is when it comes time to peel back the sheathing, put new fireproof windows on, shingles, all of that's gonna have to, you're not gonna be able to hang over the side of the building to do that.
Yeah, that's when we'll need some access,
But I think
certain
we
width,
we need to give
put the staging on.
clients the opportunity to review this,
Yeah.
this
But
engineered drawing.
But
Yeah.
this isn't
It can all
anything that,
happen, it can all happen at the same time.
Yeah.
I agree.
But I don't think that, just looking at it quickly, I don't see the
Oh,
end.
I don't think anybody will have a problem with
Right.
foundation.
No.
I mean, if it were my job, I would move it 5 feet from the lot line so you don't have to come back here. It's 5
Yeah.
feet.
I know,
But
yeah.
that's
He doesn't
just
want to
me.
move it, doesn't
So-
want
Wouldn't
to
want
move
to
it.
come here.
So you're right. Perhaps you could, since you are going to know better than the owner, and as Arthur mentioned, the owner is not represented by counsel at this point. Perhaps you could put together a list for him of like what things you are going to need to do that you
Yeah.
need to access
Yeah, I can do
Arthur's
that. I
client's
mean-
property, and then, or you could even email to your client, and then he can,
Yeah.
get the process going, because I don't think Mr. Jemison, he may not know all of what's, he's relying on you for that kind of thing. So maybe you can do that and get that started with Arthur.
Yeah, we can do that, yeah. I
Because
mean, I'll talk to him and I can get that ready.
Yeah, because that's what we'd like to see, is that Arthur's clients are aware of all the steps that are going to happen on their property, and that they're agreeing to it and know approximately when it's going to happen and what they can expect.
Just
Okay.
for the applicant's sake, I mean, we're all okay with the construction methodology in terms of the foundation? It's being done from the inside, minimal disturbance, no excavation.
we've seen this before.
Yeah. So we're good with that. It's just the next piece. So, having said that, do we want
We've
to?
seen that before too.
Yeah. Do we want to continue to September 6th? Do we know that that's possible?
There's also September 11th, which just gives an additional week. It would have been the same week as our other hearing. I realize some of you are leaving on the 12th, but September 11th is a Tuesday. The room is available from 11:30 to 4:30, whereas the 6th, it's only 1 to 4.
You think we're gonna need?
You never know. I haven't,
I'd rather just do
the
the
deadline
6th.
for the September meeting is next Monday, so I don't even know what's coming down the pipeline. So I'm just wondering about time.
I can't do the 11th.
All right, let's
Not
just do
gonna
the 6th. Is the rooms available 1 to 4?
Yeah.
1 to 4.
All right. So are we all good with that?
Yep.
Okay. So can I get a motion to continue this to the September 6th here? this room.
Make that motion.
Jeffrey makes a motion. Who wants to second that?
I'll second it.
Susan, Lisa seconded it. Any further discussion? No. All those in favor say aye.
Aye.
That was unanimous. Thank you.
Thank you.
All right. 2318 Adam Ross, Emma Ross, they're requesting, this is 50 Okarawa. They're requesting a continuance to September 13th, but I think we can alter that to the 6th, correct?
You have to.
Yep.
All right, so can I get a motion to that effect?
I'll make that motion.
All right, who wants to second it? Mark seconds it. Any further discussion? No. All those in favor say aye. Aye. That was unanimous? All right, so new business. 2718 Patricia Martone Carollo and Joseph G. Carollo, 5 Old Farm Road.
For the applicant's attorney, Arthur Reed. This is an application relating to a lot on Old Farm Road, the new subdivision, in which my clients are in the process, who are here today, Joe and Patty Carollo are here today, along with our architect, Sophie Metz, in connection with the construction which is now underway on their property. The HDC has approved the project. It involves a main house, a pool, and a structure in the back, which has been before the HDC as a cabana, but what in fact my clients would like to be able to use as a secondary dwelling with 1 bedroom. The only issue is parking. The lot slopes substantially by more than 12 feet from the front along the road to the back. And the lot also tapers considerably. This is a lot that the planning board, when the subdivision was done, had designated as a lot that would be allowed to have a secondary dwelling. Not all of the lots in the subdivision were. This one specifically was. The only issue is the parking that's required for the secondary dwelling. The number of parking spaces required in this district is 1 for the primary dwelling and 0.6 parking space per bedroom for a secondary dwelling. So we would wind up requiring 1.6 spaces. We're providing 1 space in the location on the lot, which in connection with the planning board approval was set up as being the curb cut driveway access. And the lot, the frontage of the lot contains an easement for parking along it, which is partly within the roadway layout and partly within the lot that my client has similar easement on other lots adjacent to it. In connection with all this, the layout is such that there's no place to put an additional parking space without compromising the house. And again, the house, width of the house, as you see the plan, across the lot is dictated in large part by the fact that there is a flat area there, or a reasonably level area, which can be used for the house, and then it slopes off to the back so that if you had the main house turned around, say, so that it is narrow and long, you're dealing with having it run down the hill, which would not be a good situation. I'd like to ask Sophie Metz, the architect, to come on and explain the siting on the lot and also help me with answering any questions.
Well, we also just wanted to clarify, we read letters from the neighbors, and my concern was maybe they were a little, didn't quite understand the situation. That the design that we did for our clients from the get-go was never to have 2 parking spaces because it's such a small lot and there's major drainage complications in that whole development. And so the thought was always to have as much yard as possible. And the house, we actually downsized. You know, we didn't max out the house. We used like 80% of the ground cover between those 2 structures to keep as much yard as possible. And so the sacrifice in doing that and just giving them the one lot was that they always knew that there was a risk with this back structure. But so the neighbors seem to be pushing for 2 parking spaces, but that's not really what we're asking for. We're really just asking for permission of what the interior of the back structure, how that would be outfitted. You know, will you guys give us permission to count that as a secondary structure or not? And what, you know, we thought that the design was respectful to the neighborhood in the sense that it's the smallest house in the subdivision and just trying to create as much open space as possible. So I just was really wanting to speak to what the neighbors' concerns were, because I don't think that they're understanding. Two parking spots will never happen on this lot, as far as we're concerned.
If I may, I know that the letters received refer to the Architectural Review Committee. First of all, we have approval from the Architectural Review Committee, and secondly, that's a private organization, nothing to do with zoning or any permits be granted by the town or through this board. All we're asking for is a special permit to basically allow the number of parking spaces on the lot to be the one space that's shown on the plan, and to waive the additional 0.6 parking space in the light of the fact that there is, that the lot lays out the way that it does, and that there is additional parking immediately available on the street in front of the property, partly within the lot as a result of the planning board layout. My clients, as I said, are here, and I know that they would like to address the board and express their intentions with regard to the use of the property and why it's important to them that we be able to obtain this relief. Patty?
Hi, everyone. I'm Patty Carollo, and it's my husband, Joe, and very nervous, sorry. We have 2 grown daughters, Elizabeth and Emily, and we got engaged here on Nantucket 32 years ago, and our whole family fell in love with the island. And we've come every summer for a year. And 2 years ago, when our youngest decided, or was finishing up college, we said, what's the next chapter? And we decided to come out here and live full time. So we bought the lot. We sold the house our kids grew up in. We rented a place around the corner out here. And we've been there for the past 15 months. We love the year-round community. We're getting involved. We joined a local church, and so we're retiring here. And so this is our year-round home. And so 95% of the time, it will be just the 2 of us in the home. Joe and I both work at home, so having the second dwelling would be nice for my parents, who are 90 if they visit, and our 2 girls when they visit, and to have them be comfortable, and we can still work and live out here. We have no intention of ever renting. We have 1 car. It's been great for 15 months. We don't want another car. We can walk to town. We like the green space. That was always the plan, to have 1 car in the driveway. And 1 car's been great. We walk to town for dinner. We go to the movies. Frankly, it's too hard to park downtown, and 1 car's perfect. So, so we thank you for giving us a moment. And maybe Joe would like to make some comments.
Hi, I'm Joe Carollo. I actually, my points have already been made a lot better than what I would say. I've read through the opposition, and there seems to be a focus on the Architectural Review Committee, which isn't an issue because we already have full formal approval from the Architectural Review Committee, and that we would not redesign to make it a 2 parking space lot, because we don't want to. We love our design. We don't want to compromise the design, but we also don't want to compromise the green space that we have in front of the house. So we're just asking for the ability to have the second structure be considered a secondary dwelling, so that if when we do have family, our daughters, parents, etc., visiting it, it's a little bit more space for them to visit. So. Thank you for your time. Thanks for your consideration.
Thank you. Okay. Questions?
Is there an issue for us as far as notice with the abutter who said they didn't get the notice? That was this one, right? Because she just didn't pick it up.
I can't know why they don't get their mail. Somebody was in the mountains of Utah and didn't pick up a mail. That's not this situation, but I hear all kinds of
Right,
reasons.
right. But it's
That's
not, we just have to send it.
And I spoke with these people
Okay.
and emailed them. So.
I just want to make sure that we.
And everything's included, so you have, it's not like, I mean, there were 2 comments.
Okay.
Can I ask, I have one question. So already the one parking space is undersized, 7 by 17 instead of 9 by 20?
Which you're allowed to have. One residential parking space can be 7 by 17.
Is that
only if you only have one?
Yep, it doesn't specify otherwise.
I didn't think that was the case.
I know, I would think you'd have to have one normal sized and then one, if you had a second, could be 7 by 17.
That was my understanding.
That's not the way the bylaw reads.
Do you have the bylaw?
I'm not carrying it around with me.
I can look it up. You have it right,
Why
you have
not?
it right there, right, Eleanor? Did you just call it the Bible or the Bible?
By law.
By law, not the Bible.
Well, it kind of is our Bible.
It
isn't
is. It is. It's hard to find things in it, though.
Same with the real one.
Yeah, that's right.
Well, while we're looking that up, yeah, was this the plan that was submitted with the building permit application showing the 7 by 17 lot parking space and only one of them?
It was, and it also, the neighbors, so these guys, the design was submitted to HGC almost 2 years ago, and the neighbors have always seen the same design from the get-go. And in the development, each lot was designed into a big part.
Yeah, you should go up to the mic. I'm sorry. And did you identify yourself?
Sophie Mitz
Yeah,
for the
I
applicant.
know you are.
In the development, they designed curb cuts, sort of nice granite curb cuts very specifically for one car to this lot in particular, and we are using that existing curb cut that was designed in.
All right. Anybody else have any questions right now? I mean, it sort of seems to me
Okay,
that.
I've got it here. It's
All right.
section. Section 139-18A6. It says head-in 90-degree parking spaces and 45-degree parking spaces shall not be less than 9 feet in width and 20 feet in length. The required length for parallel parking spaces shall be not less than 20 feet. For residential parking only, one required parking space may be reduced to a minimum dimension of 7 feet in width and 17 feet in length. Well, it doesn't say anything about the number of spaces.
I think the idea, though, is that that's for a secondary space.
It's not what it says.
One of them, not
Yes.
the one. That
Well,
would
I
be
mean, I
my
don't-
interpretation
right.
of it.
No,
Anyway,
it says
but that's
one
not-
space, and
We're not
we've
talking
got one
about the
space.
size of their space. We're talking
It's
about whether or
clearly
not they can have a second space.
Yeah, it's clearly
So.
unclear.
Yeah.
Let's go to the audience first, and then we'll come back to this.
I'm Jim Grant. I represent the original developers and also owner of 6 properties, G&G Development, and also the members of the Architectural Committee, who could not be on the island today. I go back to the original planning board on this subdivision, and I know how strongly the planning board told us that we needed to have 2 in-lot spaces, and that all the lots that were all the space that was taken from one old mill court, 5 Old Farm Road, 3 Old Farm Road, and 2 Red Mill Lane were to be used as summer overflow parking only and not counted as our lots. Since that time, we have worked with 5 owners who have bought lots. I have letters from 2 of those owners, so I basically represent 8. I know, I think there was one other letter that was sent in. I don't have that letter with me. Everybody is pretty strong about the fact that they want 2 in-lot parking spaces. The reason being, and I understand, Patty, that this is their home and this is going to be their home. But if it is ever sold and gone into the rental market, now we're going to overload the subdivision. and that's not exactly how the subdivision was planned through the planning board. As far as the architectural committee is responsible for the building itself. No time have we commented on the hardscape, nor were we told that that was a firm and final hardscape. So basically, we have the same problem at 3 Old Farm Road. We opened up the single curb cut in accordance with the submittal for the building permit. It has been opened up. We have 2 parking spots, and we gave up green space to do it. It wasn't easy to do. It cost us a lot of money. I know that recently the Stoffels, who are in 2 Red Mill Lane, were faced with the same problem, and it was assumed that they were going to put tandem 2 parking spaces, and now they have been able to do that. We have approximately 5 more lots that have to be planned and built. We own those 5. We intend to put 2 parking spots, and those lots are smaller than 5 Old Farm Road.
Just one question. On this subdivision, the original subdivision plan, you have these curb cuts that are, looks to be single car width. Is
Right.
that what was planned on tandem parking? Is that the
In that area, yes. Because the lots are only 65 feet wide. So it was thought that there would be a driveway type of thing in tandem. We in doing 3 Old Farm Road, decided to put side by side and have built a structure to support 2 parking lots there, and was approved through HDC, through building permit.
Could these guys widen that curb cut to
Yes.
2 cars wide?
Just like we did. All they have to do is ask for a curb cut permit.
You wouldn't get into a second
I mean,
space.
technically, the 1 car width works for 1 house.
Right.
Right.
That's
it's only
right.
when you want the second house.
Right.
And or if you're like most people and have 3 or 4 cars, you might want more spaces. But
Right.
the one
They're
car,
not required to put 2 spaces in unless
No.
they have a second dwelling.
But if they chose to, they could widen that curb cut.
Yeah.
2 cars wide. And
We already did it.
and not affect the off-street.
We did it at 2 Old Mill Court. We did it at 4 Old Mill Court. I know Lindsley did it at 1 Old Mill Court, not on Old Farm Road, but on the side roads. We all have much wider aprons in the houses that have been completed.
it does look, Jeff, if on page 65, for what it's worth, that you could widen
No, that's what I'm
Yeah, you
to the
could.
2 edges of the parking spaces. It's delineated on the street.
Yeah, you could, that one, yeah, I think.
I mean, that should be 20 feet.
And just frankly, I think you could get 2 cars on this one.
I mean, you might have to move the building back a few feet.
I'm not sure you would. I think
Well,
Well, you
Well,
gotta
the
get
window well.
You gotta get 1 9 by 20 if you're gonna
Right.
do it.
And the window well is in the place.
Any proposed spots,
Then I would.
17.
Yeah.
Otherwise, you want it to be 9 by 20.
Right.
Yeah, I mean, the building is not built, correct?
And it's staked.
Right.
Yeah.
So, I mean, there can be modifications made.
Right.
To its position, if nothing else.
Mhm.
Other than the fact that I mean, it is.
It's narrow, so as you slide back, it's got to be
Yeah, I
made
think
smaller.
If you were to slide it back some, you'd be
But you got to put a window well in a different location because that's sticking out too far to get enough depth.
well, I think you're right there.
Yeah, so there would have to be modifications, but I mean, I have a hard time seeing my way to granting a variance for a required parking space.
It's a special
Special permit.
Well, or a
but-
special permit when it's required.
Frankly, I do too, but I would also add though that if they needed to, and in my opinion, if they wanted to come here with 2 smaller spots, I don't think I would have an issue.
With the 2 7 by 17s.
I don't, or at least maybe 1 7 by 7.
Which is what they have
No,
now.
but that they can,
Which they can
But I
do
think
by,
if you create
yeah.
two spots on this lot, you could probably make the spot to the east, the conforming spot, and the spot to the west, maybe from this.
Yeah,
Where you get a
I
little
agree.
closer to the property line on the east side.
It would have to go right to the property.
Mm-hmm.
yeah, I think that's largely my feeling. Is there anybody else in the audience did want to speak about this? No. So.
I mean, and I agree with the developer's assertion that if you guys sold this place, I mean, who knows who would buy it? It would probably become a rental machine like just about everything else.
And cars aren't getting any
Cars would be
smaller.
Even if you own it forever, you're supposed to have the two spots.
Right.
And,
If you want to dwell
in. And it's a new place, and you should be
There's no
able to
reason why
provide
you
them.
shouldn't be able to provide them. It's a new construction.
So just for clarification for my clients, I just want to make sure that they have this correctly. So option, if they want this, the structure in the back, these have all been approved and they have a building permit for these structures. So the design as you're seeing it. So the option one is that they keep what they have there, but
They don't
that
have a
back
building permit
structure.
as a dwelling. They
Right.
have a building permit as a studio.
Right, so that's what I'm saying. So they can either stick with what they have now and that back structure can stay the structure as it is, but it can't have an oven in it. It can't be a full
Use-
legal second dwelling.
It can't be used for sleeping. You can't sleep in it.
So that's option one. Option two is that we would go back, push the house, allow for these 2 parking spots and just sort of stall construction until you guys approve those spots off the road.
Well, you don't have to come
need
back
us.
to
If-
us
if
then.
it complies,
If
you don't need to
you
come
don't have to
here.
come to us.
If we
You're
wanted
only
the
here
smaller
because you're
ones,
not
you guys-
compliant.
No,
or
if
don't
you had to
wanna
do
comply.
smallers,
The
but if you could do
smallers.
one regular size and one 7x17, you wouldn't even have to come to the ZBA
Right, we just go back to HDC for changing those things.
for the landscape approval. You
Right.
mean? Yeah.
Well, the house too, because we'd be moving the house.
Understand what we're talking about here?
No, I fully do. I just want my clients to not leave the meeting and understand. They have 2 options. One is that they stick with it as it is, and that back house can't be used.
Well, I mean, I still question whether or not that can be 7x17 without having one regular size spot, but that's not it before us.
Right.
Yeah.
I mean, we trust Arthur. If that's what he tells us, that's.
Yeah.
Okay, but are you guys understanding the two? Your two. Okay.
I mean, ultimately, that would be up to Marcus.
At the end, I just want to make sure you guys.
Yeah, there is a risk that
There's
Marcus
a
will
risk
flag
that
it.
he hasn't caught it on the application, and when you go to provide your sign off, it's not big enough. He might not give it to you. So
This is the zoning enforcement officer that we're talking about.
One point, by the way, is the request that we have before you is a special permit, not a variance.
I
You're referring
understand
to a
that.
variance,
We understand
but
that.
It's a special
Lisa
permit.
misspoke.
I
She knows
misspoke,
that.
but I understand. I still have the same opinion.
So, having said all that, what do you want to do? You want to us to vote on it, or do you want to withdraw it, or?
I just wanted to comment on I just was reading the planning board decision, and I don't see anywhere that they address parking or that they want 2 spaces on, or it's not listed in any of
Well, they only need the 2 spaces again because they have the second dwelling. If they only
No,
have
but I
one
know,
house-
but the developer was representing that the planning board was very adamant about not overburdening the roads and having 2 spaces on each lot, and that's not. It's
not
not
written.
carved out anywhere in the
Right.
in the planning board decision that is.
That's right. There's no language in the planning board decision about that at all.
No,
Also,
so.
if you look at the architectural review, I mean, the bylaws, there's nothing in there about parking.
Right. This is solely because that wants to become a second dwelling.
No, that was addressing
Oh.
the
Got it.
opposition, which said that there was a bunch of discussion around it, which we weren't privy to.
Yeah, it's also the architectural review committee that did approve it. I feel like if there was an opposition to the parking, at that point it should have been addressed with the homeowner when the design came before you. But that's neither here nor there because doesn't really impact our decision. But,
Well, I also don't think it's incumbent upon the architectural review board to know the zoning bylaws.
No,
to
I'm
parking.
not talking about zoning bylaws.
about
I'm
the number
talking
of
about
spaces.
their internal. If it is parking is such an issue and it's such a, everyone needs to have 2 spaces and the curb cut and all this, and that's the big push. I would have thought that the architectural review board would have addressed that with the owners before they came here to present the design that had already been approved by the architectural review board in their internal checks and balances, because that would have saved the applicant time and money if they had known that like, I don't know why you would approve it and then object to it here. It
Thank you.
doesn't make sense to me.
Fair enough. I don't think it's a compelling reason to.
I'm just
I
saying that it's confusing for the applicant. I
Yeah,
think the
yeah.
applicant came here in good faith thinking, you know, we've got this approval and this isn't, and I think now they understand that there's, the secondary dwelling does trigger the requirement of a second space.
Yep.
Mm-hmm.
All right. So what do you want to do, Arthur?
You might as well vote on it.
Okay. Fair enough. All right. So will someone make a motion?
I'll make, oh, go ahead, Jeff.
Where do we vote in?
Well, you
In
can
ma-
either
in the
make
positive.
you can make the motion in the affirmative and
See
grant
how
the
it-
relief as requested.
Right.
And
See how the vote goes.
see how the vote goes.
I'll make that motion to
All
grant the relief as requested.
All right. Someone second that?
I'll second it.
All right. So any further discussion? No. All those in favor of granting the relief, say aye.
Aye.
All those opposed, say nay.
Nay.
Who's not voting?
4-1 against.
Well,
Michael wasn't
were you
voting though, right?
Were you sitting on in on it? Did you vote?
Everybody voted except for Michael.
Okay. So, but there was only
I
5
voted.
of us voting, really.
So I didn't vote for it.
Jeffrey didn't.
No, did you vote, Michael?
I did.
Oh, you did. I'm sorry. I thought you didn't.
Nay,
you
right?
voted?
Yes.
Yeah, 4-1.
Thank you for your
Thank
consideration.
you.
Thank you.
All right, moving on.
No, I gotta get off this. Yeah.
I can sit on it.
All right, 2818.
Well, you need Michael though, right?
Well,
Or
we
no,
need-
Mark is coming.
Mark is coming back.
Mark is coming back.
3, 4, 5.
Mr. Ford, is that?
In the building. All right, 2818, estate of Pauline Dalton, owner, and Amy Vance and Joseph Dworetsky, applicant. 8 Shawcombe Road for the applicant.
Good afternoon, Sarah Alger for the applicant, and the applicant Joe Duretsky is here with me. This is an application for a special permit under 13933. What we're seeking to do is to demolish the existing ground cover and rebuild it in a different configuration. We're not looking for any additional ground cover. This property is in that area of Shimo that used to be LUG1 and it was then upzoned to LUG3. It had, under that kind of quirky piece of 13916, the benefit of LUG1 zoning until I believe it was January 1 of 2000 when that protection was taken away. Prior to that time, the property could have gone up to 7%. It didn't. It actually at one point was as high as 4.9%, but given the change in the interpretation of the way ground cover is measured to the foundation and the exclusion of gazebos, we lost 0.1%, so we're at 4.8%. And we would like the ability to, as you know, we have to come in advance before doing the demolition to get approval to reconstruct it.
Huh. My thing just disappeared. Okay. Does everybody understand what's going on? Anybody have any questions? I'm sorry,
I have copies of the plans if you want me to pass them out.
I'm good. I just have to find it again.
89.
I did bring just.
I'll have a copy, Sarah.
Okay.
So I don't have to
I brought
fiddle and diddle here.
this 2000 August 18 2000 plan just because to show you, so you can compare them, because that at least establishes a 10-year.
I did find it.
You know, that that the structures are grandfathered. There's one structure that's new, and that's a shed, and we have not counted that towards ground cover. We're counting that as our 200 square foot shed, but we'll probably get rid of that and actually do a 200 square foot.
So the two plans that you presented to us, one says 4.9%, the other one says 4.8%.
And the 4.8 is the current.
Is the current plan from foundation, correct?
Correct.
All right.
Yeah, and
All
that's
right.
dated July 11, 2018.
Okay, all right, so we don't need to look at the earlier plan that is no longer current.
No, the earlier plan is only helpful in
It's
that it
2000
shows,
plan
it
and-
shows that the structures have been there at least 10 years.
Right.
They've been there longer,
Okay.
but
All
I
right.
don't know. I
Yeah.
thought you might ask me, so I decided to.
You're so
here
good.
for a change.
All right. Does the gazebo doesn't even count, right?
Not
No.
anymore. It did previously, but it no longer counts.
All right, and the playhouse is what you're describing as, oh no, there's a
No.
wood,
That doesn't
I see
count
the
either.
shed over here.
The playhouse actually does count. The shed that we're not counting is kind of tucked behind the garage.
I see it now.
The playhouse counts?
Yes.
Oh,
All right,
at 68 square feet? Oh,
Hey,
because of
any
the gazebo?
square feet we can get.
Oh, okay, I get it.
more is better. How does everybody feel about this one?
It's a shell game.
And that aluminum carport, as much as I think it really does add to the ambiance of Shimo, will be gone. We're not counting that as ground cover.
I don't have any real problem with it. I mean, you could go through the
Lots of
machinations of
Yeah.
trying to keep a wall kind of thing, and
We're also bringing, I want to point out, we're bringing the property into compliance. That garage, second dwelling structure is currently in the setback. When we take it down, we'll have to bring it into conformity. So we're actually curing a nonconformity.
I don't know that we've certainly, have we done this before?
Yes.
Yeah.
Monomoy.
Monomoy, give me a.
I think you sent two, you referenced two of them, didn't you?
It was Ken Gullerson's client.
It would have been great if you'd done it at 72 Monomoy, but
That was not gonna happen.
We're not speaking about that.
no, we're not.
You know, they're asking permission ahead of time, seems reasonable to me.
Mm-hmm.
Is there anybody in the audience who wants to speak about this? No? I don't have a problem with it.
I have no concerns.
Kieran?
I mean, I don't have an issue with it. I would say maybe no building during the summer, just in case of neighbors, but at the same time, it's far enough out there.
We've had no,
Mail.
feedback from any.
Well, and/or we
A letter
never
said opposition.
do that anywhere except in town.
Yeah.
Right, and that's.
So I don't want to start that one.
No.
Yeah.
Yeah.
Okay.
And I don't want to impose that condition, certainly.
No.
Nobody's even asking us for it.
Yeah,
No.
or letters of concern.
Susan, what do you think?
I'm good with it, yeah.
All right. So, can I get a motion to grant the relief as requested?
I'll make that motion.
I'll second it.
All right, any further discussion? No, all those in favor say aye.
Aye.
Wait, who made the motion, I'm sorry?
Jeff made the motion, Mark seconded it. It was unanimous. Thank
Great,
you.
thank you very much.
20,
very
oh,
much.
I'm not sitting on the next one.
What's the next one?
Oh, you guys can sign these while waiting for
There's
these.
two of those.
I can't give them both of them.
Is Gilbert saying the next one?
Yeah.
Okay. That's it.
So you gotta grab Michael, I'll get him. And you leave? Casey, so you're running the meeting.
Am I running this one?
Yes. Good practice.
This is very legal on this. Yeah.
This is all of us, 1, 2, 3, 4, 5.
Yeah, this is us.
Okay. So this is 2918, Gordon E. W. Gilbertson and Nancy Ann Gilbertson, and 34 Dukes Road LLC. 32 and 34 Dukes Road.
Good afternoon, Jessie Brescher for the applicant. This is an application first either for a finding that relief is not necessary because in fact there was no merger, or in the alternative, a variance pursuant to 139.32 for a waiver of the provision of 139.2 and 139.16 to confirm that the adjacent properties have not merged and remain separately marketable and buildable. The basic situation is that Eric Gilbertson in the mid to late 70s created this subdivision, and I think went back and forth with the planning board for years, it seems, but the end result of which was that the planning board approved the subdivision. He then sold and transferred lots basically amongst his siblings back and forth, and they all maintained the ownership up through 2014 when his sister Charlotte passed away. She was a resident of Florida. There was a lot of litigation surrounding her estate, the result of which was a settlement agreement between the various parties that Gordon, who is one of the brothers, was to become the owner of 34 Dukes Road, which is a lot that had been owned by Charlotte. The issue is that Gordon already owned 32 Dukes Road. The agreement was done in Florida. The parties had no idea. They never checked with a Massachusetts attorney that I can tell regarding the fact that putting them in common ownership was going to risk a possible merger of these two undersized lots. So since that time, once we realized the issue, we've had the Florida mediated settlement agreement amended and approved again by the Florida courts. We've since filed copies of that with the Nantucket probate court and have recorded a confirmatory deed transferring the estate, or excuse me, the lot, or not lot 34, excuse me, 34 Dukes Road from Charlotte's estate directly to the 34 Dukes Road LLC, as opposed to being transferred to Gordon and his wife Nancy. So as it currently stands, 34 Dukes Road is now titled in the name of 34 Dukes Road LLC, and 32 Dukes Road is owned by Gordon Gilbertson and his wife Nancy. So that's the background. I'm happy to answer more questions if there are any.
Does anyone on the board have any questions?
Will you write a letter of non-contiguous ownership regarding these lots when it comes time?
With this relief, yes. I mean, so the issue is that with the amended settlement agreement and the approval by the court, technically speaking, that approval goes back to Charlotte's date of death, that the title vests in the ultimately awarded title holder as approved by the Florida court. So technically, yes, his ownership, or the ownership of the LLC, goes back to 2014 when she died. As a practical matter, it's murky because of what else has happened, which is why we're here. That's the problem. My guess is that a variance is probably more likely than a finding that it's not necessary, but wanted to cover our bases and request both. The lots, I forget which is which, but one is over 17,000 and one is over 14,000. It's closer to 15, I think, and they are in the R20, so the 20,000 square foot zone. So they're certainly undersized, but not sort of grossly undersized.
How do you guys feel about?
Are these lots for sale right now?
They are.
Who's trying to sell
them? Nancy Ann Gilbertson, Gordon Gilbertson, and the 34 Dukes Road LLC.
And they're being marketed as separate buildable lots.
That was the intention, yes.
When did they figure out that it merged, or how did they figure out that it merged?
Oh, I've been working with the Gilbertson families close to over 4 years now, I realized. And it came to our attention because Charlotte passed away and then Eric passed away. And there was litigation surrounding both of their deaths in Florida and a variety of other issues. And they contacted me to deal with this. We'd resolved all the other title issues, of which there were several. And then this recent issue came to my attention 6 months ago, not quite. I mean, I think maybe 5 months ago. And then we looked at everything and realized that the Florida court stuff had merged it.
Owned by the Gilbertson family?
Yes. Under the current zoning bylaw, there was a revision made a couple years ago where it's about the title ownership as opposed to the underlying control as a way to differentiate, because we'd run into similar issues years ago, and it was I'm trying to think of what exactly prompted the zoning change, but it was, I believe Arthur Reed proposed the zoning change at that point, and it was adopted. So it's now, there's no longer the obligation of transferring attorneys to look behind the record title. So it's just what's on the Registry of Deeds dictates who the owners were as far as the merger issue goes.
So the LLC alleviates.
Correct. The LLC is legally different from the Gilbertsons and therefore is separate record legal ownership as far as that goes.
Tax records give us a better indication of what was going on?
What, the real estate tax?
Yeah.
They were, up until Charlotte's, actually even still now, I believe, in Charlotte's date of death, which was 2014, it was taxed to Charlotte as the owner. And so all of this has sort of transpired as a result of her death and the ensuing litigation. I can double check. I believe the tax bills after her date of death ultimately might have been sent to her estate for a while because it remained unsettled for a couple years.
I think what he's asking is, are they receiving two separate tax bills for the
Absolutely.
Versus one for the
Absolutely, there are
lot?
two separate tax bills since the 70s, I believe, when the subdivision was created. Yeah, they're certainly being taxed as two separately sort of standalone buildable lots.
Was that what you were getting at? Yeah.
Sorry. Okay. Thank you for clarifying.
And do you know how long has it been R20?
I don't know off the top of my head.
I was
have
just
to go
curious about like when they became undersized.
I think they've been undersized since Mr. Gilbertson created the subdivision, which is why he was back and forth with the planning board. I think the zoning change, again, I'm not sure of the exact dates, but sometime in the mid to late 70s, and in true form, Eric Gilbertson was the owner of the whole thing and filed a subdivision plan. And I think, according to the planning board notes, it appears as though he filed it, the day before the new zoning went into effect or something, which is why there was so much back and forth with the planning board. But again, ultimately, the result of all of that after several years was that the planning board approved his subdivision, which created these lots. And to my knowledge, the zoning hasn't changed since that time. And again, since that time, when they were originally deeded out, they have remained separate, and it was just the fact of Charlotte's death and then the ensuing litigation and agreements or settlement agreements between the various parties that put them in the same ownership.
So this is just these other lots back here that are also part of the subdivision, 85, 83, 81, 79. They're all vacant?
They're all vacant, and they have all since been sold. One buyer bought, I believe there are 5. There are, I think, 4 across, and then a triangular piece that was the land court portion.
Oh, 79. So what is that? What is that? It's not a spite strip.
Basically, it was a spite strip. Yes, that's partly why I was dealing with them for 4 years. We're clearing up all the title to the back stuff on Vestal as opposed to Dukes. And that's all been resolved, and I believe the new owner of the Vestal Street pieces is combining all of that together, coming and going to the planning board with a new subdivision plan to create, I think, 3 or 4 currently compliant lots under their new plan, but that's nothing to do with this. We're just dealing with the Dukes Road portion.
Just the Dukes Road.
Mm-hmm.
Does anyone have, well, is there anyone in the audience to speak to this one? Could you come to the microphone? Is that one on, Terry, do you think?
Yes.
So if you could just identify yourself for the video.
Right, my name is Paul Dotterum, and I live at 89 Vestal, and I received the document to come today. We just were looking for more clarification on how what they're trying to do affects the lots that are on Vestal that go down to Duke.
It doesn't seem to have a connection.
This has nothing to do with the Dukes Road lots, or excuse me, with the Vestal Street lots.
Okay, so basically you're trying to have two separate lots where you're talking about, so that you could sell them as separate lots.
Correct. Correct. 32 and 34 Dukes have been sort of separate and, again, possibly merged because of this change. And so the idea is to acknowledge that they maintain their separate status so that they can be sold separately. Mm-hmm.
And how that won't affect the lots that are on 89 Vestal?
No, they're totally separate from the Vestal Street side.
Right.
Clarify, you are on Dukes
Right. I am on Dukes Road as well.
Mm-hmm.
My property goes from Vestal down to Duke.
Right.
Mm-hmm.
You can see that on the map.
And I was just concerned that the lots, the 3 or 4 lots that are next to mine, that I assume attached to yours, will be subdivided also. So instead of
Correct. The Vestal Street pieces are now owned.
Right, I understand that. I guess I'm just looking for clarification of what happens to that property. Would that affect someone coming in and be able to subdivide the 3 or 4 lots that are on Vestal that go down to Duke? So in other words, cutting them in half.
Well, that, no. Well, no. So what do you want to look at the map here that I'm looking at? Maybe that would be clearer for you.
Sure.
You can, here, let me just show you so you're right here, right? This is you, and you come in over here.
Correct.
So so these two are the lots we're talking about. Basically, whether this one can be sold separately from this one. These 4 and this little one here, the 79, I believe Jesse was saying, have already been sold, and that person is in the process with the planning board to create a subdivision. So you might.
They're going to combine all of these together and move lot lines around to result, I think.
Like a neighborhood type?
I don't know. You'd have to.
I think they're doing three 20,000 square foot plus lots. I think they're rather than 4 lots that are all undersized.
Oh, I see.
The end result is, I think, ultimately 3 lots that are at least 20,000 square foot apiece.
But if you have questions about that you could address to the planning board or the planning staff. And Eleanor, would you deal with that? Would you field that, or who should?
You can email me and I can forward it to the right people.
Yeah.
This is
Wouldn't we be
completely separate.
Yes,
Yeah.
If he's
Yeah.
within 300 linear feet, correct.
Right, so you also get notice for this because this is a public hearing as well. But these 4 other lots, that's a different application, a different board, and a different owner. So we're only talking about this lot, and this lot is undersized. It would not be able to be subdivided, and there would be, if they sell it and build on it, they would put a driveway there.
Right, in another house.
Yep.
But if it's combined into one, they wouldn't be able to do
They'd still be able to
do a
put another
secondary
house.
dwelling.
One house, there could possibly be 2 houses, or primary and a secondary dwelling.
Yeah.
As opposed to 2 separate lots.
Oh, I see. So there's still to be another building all the same lot.
Yeah. Does that clear up your question?
It does.
Could I just add a correction?
Yeah.
I'm not involved in the lots behind, but I did want to mention that I think what's happening with those 4 lots is an A&R, so there won't be notification. You'd have to go to the planning board and find out about it.
Yeah, so
I believe it's going from 4 lots to 3 lots.
Right,
though.
that's what
Right,
Jesse
it's
said.
approval not required.
And it's approval not required. So you'd
6
have to.
houses, I mean, it could be 2 dwellings per lot.
Right. Again, but that's before planning.
That's the planning
so
board.
if you email Eleanor, she can get you in touch with the right person, because we don't know. This is all just, we're doing guesswork right now, so you should speak to that. Thanks, Sarah.
Great, thanks. Appreciate
that. Anybody else?
Yeah. Stephen, did you want to say something, or? Same thing. Okay.
Thank you.
How do you guys feel about this one?
Going back to Jeffrey's point, I wouldn't mind seeing some sort of affidavit from, the owners saying that that was in fact the case. Just another added layer.
Okay.
I mean, if you've got documentation from Florida that this transfer,
I-
these were separate, then you should be able to.
I do, and
write a letter.
it's recorded at it's filed at the probate court. It's because of these. It's because it's murky. So we have a buyer who's interested but needs clarification and wants to make sure that this is going to fly, and so that's why we're here. So I don't think, quite frankly, that a letter of sort of non-contiguity is going to cut it. I think that my letter plus this would work, but I don't think they're going to.
So with our decision then, would we want to reference the filing at the probate court or have that as an exhibit to our decision? Would that make you more comfortable, or would you still want an affidavit from the?
We need some.
I just want to make sure we cover all the bases so nobody comes back and says, hey, this was the case, why didn't you guys deal with this?
Mm-hmm.
Because we know we always have to worry about setting a precedent,
Mm-hmm.
what have you, and somebody could just say, well, their case is murkier than this one.
I mean, if you were to apply for a building permit,
I mean, if there's a court order that says that this property back to 2000, whatever, 14
Right.
is owned by this LLC, and it amended the gifting of the property,
The issue is, so at the Registry of Deeds at the moment, there is a deed from the estate of Charlotte to Gordon and Nancy, which was in accordance with the original court agreement. Then there's the amended court agreement that says, wait a minute, that was a mistake. It should go not to Gordon and Nancy, it should go to this LLC instead. So now then there's a confirmatory deed that deeds the property from the estate to the LLC. The issue is, because of the confirmatory deed, or because the original deed, technically the confirmatory deed miraculously goes back in time. That intervening deed is on there, and it doesn't look good. I mean, again, the reality is that because of the amended court order and the confirmatory deed, legally it goes back. But
why don't you apply for a building permit, and get, and then get the permit rejected, and then income.
because we're trying to avoid all of that.
why do you need, I guess if you have the confirmatory
Trying to be proactive.
deed, but if you have a confirmatory deed, why do you need to come to us at all? Like, doesn't that satisfy the title issue?
We're dealing with a buyer's attorney. I don't know.
Are you the buyer's attorney, Stephen? No?
No, Sarah
You
is the
are?
buyer's attorney.
So
I don't
Sarah,
sure
so
if you
right,
wanna.
if there's a confirmatory deed and then that looks back, then merger is just a term of art.
Yeah, merger's a term of art, but we don't have any way of knowing that when we go to get a building permit down the road, which of course we're not close to doing because we don't own the property. There's no plan, we're nowhere.
Why don't you buy it subject to a building?
Yeah, I don't think we need to do a variance.
Title insurance doesn't cover zoning, unfortunately.
What does the title insurance say about this?
They don't cover zoning. It's
And
a zoning issue and they don't cover zoning. So I don't really think I have a way of adequately protecting the buyer. Given the fact that, for a period of time, there was a deed, for a period of time, these lots were held in common ownership.
Right.
And so I either would need you to make a finding that the subsequent recording of the corrective court order and deed looks back, pushes us back, and there was no merger, therefore no relief is necessary, or I need a variance saying to the extent that there was a merger during that period of time, it isn't merged anymore.
So the first option is
or a denial.
So there's issues with both of those, right? It's sort of a sticky wicket, because if we say that we don't need to grant relief because the look back and the confirmatory deed, then does that open the door for people to get creative on merger? And I get that it's a specific situation here because of the estate. I don't really love the idea of doing a variance, but at least if we do a variance, then we have more of, or I guess maybe if we said that.
It's going to be I would think would be very hard to drum up a similar circumstance where you have a court order and then go back and have an amended court order that's corrective.
Yeah, I know. I'm just thinking like if we just have a finding versus issuing a variance. Like if we did approve this, I would want to be very detailed in our approval so that we are not opening floodgates. I'm just thinking whether a variance or a finding that no relief is needed, which one protects us more from having people get
I
a
would
little
think of variance only because you consider the peculiar, the unique circumstances of this situation is what necessitated a variance relief, whereas if not I think the finding that no relief is necessary leaves the door more open.
Right.
But whereas the variance is very specific to this particular property and the circumstances surrounding it.
How do you all feel about?
Does it make sense to put this off until our next meeting in September, which is removed, and seek out some advice from the town council? Because it's a pretty big, there's a lot going on.
Yeah. I mean, that's not a bad idea.
Right.
That's not a bad idea. That works for me.
Wouldn't be advisable to have the planning board weigh in on this in some fashion as part of town council? I mean, why wouldn't we employ any opportunity to understand this fully?
I mean, that's fine. I guess we could ask the planning board for an opinion. I don't know.
Did they say no?
I don't know why we would need their opinion, but
yeah, it's another resource.
I just think town council might.
I think town council is going to give a broader stroke.
We're also dealing with whatever Florida, their court,
probate court.
Up there, so
right.
Just seems like
it's just a better look than we can give it.
Right.
While we're sitting.
A more thoughtful decision. That's fine.
Right.
That's a good idea. We should do that.
It seems like it's complicated enough that either, as you said, either option has its potential flaws. So maybe taking the time to get some feedback does definitely make sense.
So does someone want to?
I think having town council take a look is a good idea. Planning board, all things are from before it comes here is referred to planning. I think they would have weighed in if they had concerns, but
I agree.
This gives them another month to do that, I guess.
So, does anyone want to make that motion to continue to September 6th?
I'll make that motion.
Okay. All those in favor?
Aye.
Aye.
Oh, I recuse.
Is there any additional information you'd like brought at the next meeting? Because we'd certainly be happy to.
Did you want
I mean, I
information?
think if we could have tax information just showing the two that they're separately billed, and then I guess I think an affidavit from the owners, just like basically signing off on the history, I guess, saying that this is what happened and it was not their understanding, or what their understanding was, and when it became clear to them that there was an issue, would be helpful.
Who
takes it to town council? Who moves it forward from here?
I guess Eleanor would, but I also wouldn't have a problem if town council consulted either attorney.
What was that? If town council reached out to either one, that's fine.
Fine. I'm happy to answer any questions and provide them with
I think that makes
copies
sense.
of whatever documentation they need.
Okay.
So I don't know, Eleanor, if you reach out to them or CC me.
I have to do a request for legal services. It goes through my supervisor, and then it goes to Libby, and if she okays it, then that's
okay.
This is pretty.
So we'll see you in October.
Well, I will tell you that I'm not going to be dishonest here. There's a lot of money that this board is spending on town council right now, so I'm not certain what will come of this request.
I like to keep the use of town council down, always have, but in this particular application. There's a lot going on over a lot of different years.
And the rest of the money is because of the 40B. And there's really.
Right.
There are other things too.
Well,
Yeah.
lots of things. I don't know. Seems smart. Did we get
Okay.
a vote?
Anything else?
Yep.
Yep.
Okay,
Good.
thank you.
Okay, awesome, thank you.
Do we want to get Ed back or no? How do you grant a variance for something like that?
I guess we would just say that.
I mean, because it has really nothing to do with the land.
I know, it's not.
It's not really, doesn't really
It's not
need
even a shop or anything like that. It's just a place of unmerged lots. But if they got, but if the court bought it, if the court went back and redid it, and there's a confirmatory deed, then it exists.
But that's Florida court, right? Wait, that got done in probate.
That is filed up here.
Yeah.
So.
Susan run the meeting?
Yeah, she did. She did a great job. Much quicker.
What's not quick?
Well,
I'm just kidding.
Sorry.
It was a very complicated one.
I'll get better at it.
No, I was talking to my police friends. All right, where'd Eleanor go?
She's run away. Oh, there she is.
Eleanor, check.
Yep. We're using too much.
We've used none for like 20 years.
That's that desk you bought yourself. Ed Tool.
Where was, did I miss that discussion? 3018 Nantucket Wheelhouse LLC, 13 Mass Ave, for the applicant.
Mr. Chairman, Eleanor loves it when I say this, but this matter is, I think, hopefully simple and quick. This house is actually.
It's not Eleanor who loves it.
Was that Sarah laughing in the background?
I'm not sure, because I think we asked this question.
Jazz hands. This property has been before you twice. You've granted relief twice for altering these premises within the setback and otherwise. What we're seeking here, the problem that we've run into is the process started 3 years ago, and the building permits that were originally pulled for it have expired, and when the contractor went to get fresh permits, they were told that they need to comply with the current flood code issues. The house, as it's permitted, doesn't need any changes to comply, but the cottage that needs about a foot in elevation to comply. Neither one of them needs any zoning relief, but your last decision says that they have to be compliant with the height proposed in the application. So in order to alter the height to meet the flood code, we need permission from the board to have the cottage raised at approximately a foot with an additional foundation, not in addition to the height of the structure.
Well, it needs zoning relief because it's still within 2 setbacks.
Yeah, correct. What I meant was the height isn't the issue. It's the.
For some reason, I just remember having this discussion when you were here and saying this includes the extra foot that the building code requires now.
Well,
and somebody's saying yes, it does.
It did for the house, and at the time we had permits that it was compliant with the permits that were issued. And the problem is that those unfortunately expired, and the new code applies to the new permit. So
right, yeah, I thought it was. We discussed it with the
garage.
Well,
it's interesting because the house is at the right height.
Right.
Why wouldn't the garage have been?
I don't know, but I do remember asking that question.
Yeah. It was on slab.
But weren't you actually? You were still raising the garage at that point, weren't you?
They were still making it.
They were still lifting it.
Yeah, it was compliant with the code applicable to the permits, and unfortunately, the change in code under the new permits, it doesn't impact the house, but it impacts the cottage by a foot. So that's all we're seeking to do.
Maybe the house was already. No, the house wasn't.
So we're just seeking a relief from your prior decision, which limits the height of the structure based on the plans that were submitted, to allow us to amend those plans to increase the foundation by a foot.
It's going up 1 foot
Yeah,
in addition?
correct.
And how much did it go up initially? I can't read all these.
Well, it says the existing elevation is 9.6 and the proposed elevation is 11.6.
Right, 2 feet in total. I'm just looking for the ridge height. So the ridge height is more than just 2 feet higher, I'm assuming, because it looks like it's a different shape.
But the HCC approved plans haven't changed at all. It's all, the only thing that's changing.
Correct. And there's HTC approval for the alteration, but not zoning approval for the alteration.
I don't think the ridge, if I can read this correctly,
Doesn't go up.
maybe by 6 inches.
Right. It's just a different shape. It's a broken back
It
now.
is broken back.
So I'm just curious.
Is work happening on this property? Is work happening in the main house?
I believe they've started, but I don't actually know. I know they've been anxious to.
You're gonna get us that letter from an engineer, from a registered engineer stating that that foundation hasn't been modified, right?
I will check on that. Absolutely. Thank you for reminding me.
Good memory.
That was on the main house.
Right. Just as a point of.
No. The last thing I want to do is miss the opportunity to have it done at the appropriate time.
I think they would want to miss that.
Yeah. Now that you asked the question, Jeff, I coincidentally bumped into the owner in the hallway getting his beach permit, so I know they're here. So that suggests to me that perhaps they have not ripped apart the main house while they're here.
Okay. Do we think
What is the flood? I'm
Go
sorry.
ahead.
What is the flood zone out there? What's the minimum height that this building can be? It's just the 0.6 seems a little like an odd thing. It's usually 9, 10.
You're beyond my area of expertise.
Well, I mean, I guess my point is I just want to
The
understand
base
what
flood
that
is, it says 10.4. I don't
That's
know if
an
it's,
odd. That's just is that an odd?
So that's finished floor is 10.4.
no, the base flood elevation is 10.4 and then you're supposed to be a foot above that, right?
It just seems odd. Usually it's like elevation 9. I mean, they're
Yeah,
even numbers.
I hear you.
So I was just curious what the.
I don't think so. I don't think they're all even.
You don't think so? Well, down in Brant
Well,
Point,
isn't
it's
it-
definitely. Well, you know what? It's based on which datum you're taking it from. Yeah, that could be. You might be right.
Okay, well, assuming that we're being told the truth, that the permit is, that they have is no longer valid because of the floodplain, it seems reasonable.
It certainly does seem reasonable. I just wonder why, shouldn't the relief reference elevation? Shouldn't it reference, you know,
Well, it
going
doesn't,
from elevation this to elevation that, because the floodplain is risen from elevation this to elevation?
Yeah, the existing permit has that information, and what we're just asking to do is to add to that. And if the board would like confirmation beyond my capacity, you could certainly have a condition of that we submit a certification from an engineer of those details.
that seems reasonable to me. It does say on the plan that it's at 9.6, it's going to 11.6. And, you know, again, assuming this information is correct, and that the base flood is at 10.4, so they're 1.2 above that, which is 14 inches kind of thing. So foot plus 2 inches of
Right.
wiggle room. Because isn't that the,
It's a foot above the base flood.
so.
But it just gets confusing because of the different datums and everything, so.
Right.
Yeah, I mean, I think it would be good to have a Blackwell plan in there noting what the base flood elevation is and what the new proposed elevations will be.
Yeah.
On an engineered plan, not a
You don't trust
HGC
the
plan.
architectural plan?
No, I just want to make sure that there's something written that lists the base flood elevation from an engineer.
It says here, however, to comply with current code, the proposed foundation will have to be approximately 1 foot taller. I don't understand what that means.
Yeah.
The first floor elevation and the average grid height recorded.
It is-
I think we get some numbers in there.
I think we could
Yeah.
have
Fair enough.
that certified by an engineer. No, that's not a problem.
So do you want to just, sorry, I'm meeting.
Yeah.
Do
I
you
think
want
you
to
need
just
most
make-
of that.
Did you pass?
Did you say me?
No, he didn't.
Here.
He put over here and I
Did you-
pushed it away.
It's Eleanor's.
I know it's
Take a
Eleanor's.
little piece and let's give it back to her.
I would make that motion to approve with a site plan from the Jeff Blackwell stating the base flood elevation and what the new proposed base flood, what the new proposed floor elevation will be
And
for the
then
garage.
it'll be no more than what's
So the assumption is
required,
it's
plus
no
2
more
inches.
than,
Correct.
0.2 is more than 2 inches. 0.2.
0.2 feet above, no more than 0.2 feet above the minimum first floor elevation based on the applicable datum. I think that's fair enough. More than fair.
Okay.
Because it looks like at the moment, yeah, they're
So
putting
we'll
it,
vote now,
they're putting it at the same height as
even
the
with
house.
Eleanor the certificate.
Yeah, and we won't sign it until it.
Yeah, I mean, it'll be a prerequisite for the building permit anyway.
Fine with me.
Okay.
Yeah, that's good.
Let's move on.
So I made that motion.
Second.
Okay. Any further discussion? No. All those in favor say aye.
Aye.
Thank you.
Can I just say one thing? The understanding is 1 foot, it's going up a foot to be compliant with the code.
Yeah.
Who's not voting?
Yeah. Yeah.
So was that everybody except
Everybody
Susan?
except
Yeah, just because the
Everybody
house
except-
just so
who
happens
said
to
me?
exist
Everybody
at
except Karen.
11.6. I
Okay.
think they just want it at the house height.
I should- I wouldn't brag about that.
I'm going to.
No.
All right, everybody but Karen,
We'll see.
thank you.
I mean, I'm assuming that
I know.
it's.
I just like seeing the thing.
I hear you.
Okay.
Okay,
Great.
we're done? It's 5 o'clock somewhere.
I think it's a little early,
The life of a retired man.
Who's retired?
I'm kidding. It's not the weekend.